Alrighty, so this is Diesel We the People News. One more time at it. It's been a little bit, so pardon me. Alright, took a little break and kind of watched the Idiot Box, some TV and all that kind of stuff, and kind of reset my mind on researching and studying law and all that kind of stuff. And then I went on to YouTube and checked things out. And I guess he did this here pretty recently. And I'll watch this. Now, that being said, I have read both of these that he brings up, but I read it quickly. When we read these things, sometimes we got to remind ourselves that we got to read slowly. All right? And again, everything jumps around from place to place to place, right? And hence is the reason why we always say, what? Never look just straight forward. Always look around us to be able to protect ourselves by any means necessary. People. All right? And he's an attorney, but he's an activist attorney. And he went into the sole purpose of changing the status quo because he has been harmed himself. Okay? Cops created a victim. So, over a period of time, fighting a bunch of things and all that kind of stuff, he went and got his law license to better help the people out there and to have better understanding of the process they are doing. Okay? So, this is in general about qualified immunity. How did they get it? How can we take it away from them? And all this kind of stuff, right? And he's going to describe this a little bit better, which when I read these few things before, right, I didn't notice that the 16 words was missing. Okay? And hence as I read it slowly. But again, you know, I may have read it like 2 months, 6 months, a year apart from one another. So, you know, didn't put two and two together. He was doing more investigation, how this and this and this was done, right? At the exact same time. So he created paper trail. I just kind of doing research and I'm really just jumping everywhere like the law does, jumping everywhere. I keep on hearing people that ignorance is no excuse to law. So when they end up initially coming up with that, it's because law was minimum and clearly understood, right? There was no 34 million laws, all right? And I'm led to believe and do believe that judges end up giving themselves qualified immunity due to they could not remember 34 laws, right? And since they're educated, they should know and memorize all 34 million laws, which is impossible, I understand, but I didn't become a judge. They did. They agreed to the terms. If you're going to judge somebody, by gosh, know what you're talking about and know the law, right? The ignorance of no excuse is absolutely an excuse when you can't remember, and no one can, 34 million laws. By the way, 90% of them is unconstitutional. All right, let's go ahead and proceed forward on him. Oh, let's back this up a little bit and kind of get him started. All right, this one, he's got another YouTube, and I can't remember what it was, CJ Grisham. That's his other YouTube channel. And this is the Second Amendment attorney, CJ Grisham. Okay, so I'm just going to do a partial on this. It's an hour long, so you guys go over there and check this out, okay? And that way you don't have to keep listening to me. All right, let's go. Maybe.
Qualified immunity was supposed to be, which was protecting cops in the course of their duties. The problem is now, it doesn't just protect them in the course of their duties, it just protects them against anything. So what I want to do first here is I want to, and this is going to be really weird because I'm not able to direct StreamYard into just one page. So I'm going to try this here. I'm going to add this, and I'm going to go here. Oh, wait. Yeah, see, and I can't even look at myself. So this is Section 1983. This is what we have today. This is what the Supreme Court has, when it created qualified immunity, this is what it created qualified immunity from, is 42 USC, so Title 42, United States Code, Section 1983. This is a civil action for deprivation of rights. In order to get around the sovereign immunity, theoretically, under the common law, the only time you can sue government is when government gives you permission to sue it. That's what 1983 is. 1983 is Congress saying, okay, we are giving you, the people, the right to sue the sovereign under these circumstances, right? And these circumstances are deprivation of rights. So every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any right, privilege, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress, except that in an action against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. Now, I'm not going to get too much into this last part, but what I am going to tell you is that since 1871, when this law was initially passed, there's only been one amendment. And that one amendment to 1983 is right here, except this part right here. And the reason for that is and this, I believe it was in 1996 when this was updated and this amendment was added. And all they did was make it harder for you to sue a judge for doing his job. But it still does provide a very narrow path if you do need to sue a judge. So we're going to keep that out. But I wanted to highlight to you that since 1871, the only amendment that Congress has passed to what we know as 1983, 42 U.S.C. 1983, is what I've got highlighted right here, where they essentially made it harder to sue a judge or a justice, okay? That's it. Other than that, everything else here is untouched, theoretically. But I did a deep dive and started looking into, because I'm trying to figure out what is the history of 1983. Well, here's the history. The history is this, and let me go back to this, add this up. This is, 1871. Here we go. Let me get this out of the way. I don't know if y'all can see that or not, but I can. This is what we consider, it's called the Civil Rights Act of 1871. This was passed on April 20th, 1871, and this is the law itself. Now, this might sound familiar, right? Be enacted by the Senate and House of Representatives of the United States of America and Congress assembled. And then here we go. Any person who, under color of law, or any law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the states to the contrary notwithstanding, be liable to the party injured in any action by law, suit, or equity, or other proper proceeding for redress, such proceeding to be prosecuted in the several districts. And it talks, this stuff is all codified elsewhere. But it ends essentially right here, proceeding for redress, right? And you notice in the original 1871, you don't see the part about judges. And that was added. That wasn't added until 1996. So you see that, right? You see that. Now I'm gonna bring to your attention something here. I don't know if I can highlight any of this for you. Never mind. Let's just not do that. Let's just not do that. All right. So this is it. Now I want to come back and forth to this. This is.
So I'm going to pause this right here right quick, right? So now what you got to do, one or two, go ahead and get a copy of the direct from Congress this copy, or you can just sit it, write it out on your papers and all that kind of stuff. So you want to write this out, because what we're going to do is create a notice of liability. Okay. I'm pausing here because I want to try to get the correct wordage, right? Because in order to do this, you need to give them notice of your knowledge and make them hesitate of what they're going to proceed forward on, right? So we went back, right? It's codified. Judges got more qualified immunity because, well, they can't remember 34 million. But what the judges have been doing is giving their qualified immunity to the officers as well, which judges cannot do. Okay, not attorney, not giving legal advice, this educational purposes only. All right, that's disclosure. Okay, do your own research. Said you have to do that. All right, but we're going to start off with this, and when he comes up with the other deal, and we're going to put it on the bottom, and this is why. Okay?
What was passed on April 20th, 1871. This is what eventually became 42 U.S.C. 1983. Now, what happened was, and here's a little bit more history for you, is that, let me turn this off. What used to happen is, yeah, 420. It was passed on 420. Very astute of you, ED4 Action. Back in the day, 1871 and prior, everything that was passed by Congress was considered what was called a statute at large. So Congress would pass a law, it became a statute at large. And of course, the only way that anybody knew that there was a law out there was they would have to print it up and distribute it out to the states, who would distribute it out to the cities, who would distribute, probably post it somewhere. I don't know how all that worked back then, but they were called statutes at large. And then Congress realized, my gosh, we've got, and what would happen, let me back up and not get ahead of myself, what would happen.
Okay, so this is my spin, and I'm not downing him anyway. Love this guy. Okay, it's just my opinion only. Do not take it as legal advice. Okay, now remember, at the particular time, statutes, codes, rules, and regulations did not apply to the people. So this law was actually intended, original intent, to go after the government officials and tell them, hey, these are your statutes, codes, rules, and regulations that you must go by, right? Because we stand on the Constitution. We're above the Constitution. The Constitution is for the government to stay in honor. It's the stop sign, not to trespass upon the people. Okay? So anything was written by the statute with the Constitution in mind goes directly to their employees, our servants. Okay?
Is each year...
Again, that's not legal advice. It's educational purposes only. Do your own research.
Or each congressional session, private companies, organizations, individuals would compile all of the laws that were passed, and I bet you the states probably did this as well, would just compile all the laws into a single volume of what was passed that year. I gotta try not to be too loud because I don't know how thick these walls are here, and it's 10:30 at night. But and so you'd have these volumes of statutes at large, but they wouldn't be organized. They would only be organized by what was passed. And in 1 year you might have something passed that deals with commerce, and that deals with trade, and that deals with immigration, and that deals with border disputes or whatever. So these volumes would have all kinds of different things. So the Congress in 1873 and 1874 decided we've got to do something about this. We've got to get all these laws that are all out there. We've got to organize all this stuff. And so they decided to organize everything into what was called the Revised Statutes of the United States, the first revised statutes of the United States.
Okay, we're going to pause here because I made the video a little bit long. Sorry about that because I yap. It's going to be shorter next time. Get to the point. So we're separating this out from the original statute 1871, or what Congress created law for. Okay, so we're going to go with part 2, where we can start jumping into the other ones and how they conflict with one another. Okay, but this part 1, write that down. Get that on paper. Okay? Jason We the People News. Until next time, bye y'all.